Hello and welcome to the Emerging Litigation Podcast. I'm your host, Tom Hagy. Today I get to talk to Mark Zauderer. Mark is a highly regarded trial lawyer, appellate lawyer of the whole thing. Mark has been practicing for quite a while, and we're going to talk about how how law firms and the legal profession has changed over the past 5 decades. You often hear how it is now the business of law. And Mark, let's just say he doesn't see not all an upside. He sees the profession as just that, a profession, one steeped in history and with a lot of values. Some people will argue with that. I happen to defend the practice quite a bit myself, but where would we be without good lawyers? But what is happening though as you turn these into businesses and profits start to dictate what's happening, well, some things that are good about the practice of law become challenged. He talks a bit too about the political pressures that have been put on law firms recently with regard to DEI programs and how some of those firms pushed back. So I want to get some of his thoughts on that and how that might shape the law going forward. So if you're a lawyer, you're a law student, or you're just interested in law and how law firms work, Mark has a lot of insights based on his many years practicing. And also, he's author of a book, and I want to give that a plug. It's called, let me just make sure I get the name right, Counsel, the Courtroom is Open, and it's published by Simon & Schuster. And I'll put a link to that in the show notes, so take a look at that. This podcast is based on one of the chapters in that. Let me also get that correct. It's chapter 43, and it's called What Has Happened to Law Firms. It's also cool that all of the proceeds to that book are going to go to a nonprofit called Grassroots Grocery. That is a food justice nonprofit founded by his son, Dan, and that brings fresh produce directly into communities across New York City, communities facing food insecurity. Now, Dan is a former middle school teacher. He founded Grassroots Grocery after seeing firsthand the extent, the impact that food insecurity was having on his students' families. So under his leadership, he's grown this into a large-scale community effort, bringing thousands of pounds of fresh food weekly across New York City neighborhood. So with that, here is my interview with his dad, Mark Zauderer, author of Counsel, the Courtroom is Open. Hope you enjoy it. Mark Zauderer, thank you very much for doing this today.
My pleasure.
So as I said in my intro, we're talking about your book, and in particular, we're going to talk about chapter 43, which I explained. In there, you mentioned how you talked about how law firms have shifted their focus from traditional values like law firm culture and loyalty to the profession of law to prioritizing profitability and partner income. It's more of a business. And that's a transformation that's been going on for quite a while, but you've watched it happen. So how would you say this has impacted the overall morale and long-term commitment of lawyers within these firms?
Sure, that's a great question, but maybe I could just give a little context, which would be helpful to listeners. We hear the phrase, the business of law, and I think we tend to accept it as though that's a given and that's how it always has been. But that's not how it was, certainly when I started practicing law many decades ago. The law was thought of as a profession. Sometimes they would say a learned profession, like medicine or accountancy. And law was not thought of as a business. It was a profession, often serving clients in business. So there were two different things. And over the years, a number of things I think have happened in confluence to create what we now call the business of law, which has many implications, both for lawyers and I think for clients, and reflects changes in society. So among these were these. First of all, law firms, particularly the large ones that we know, were typically in a single city. They were homegrown affairs. Lawyers often came right out of law school, joined the firm as associates. If in the 8th or 9th year, typically they were considered for partnership. The firm knew the associate and the associate knew the firm. The associate knew the firm culture. And there was a certain degree of cohesion, and lawyers would become partners, and many would stay their whole career at that firm. Beginning, I think, in the 80s, a number of phenomena emerged. we had publications like the American Lawyer, which suddenly was publishing what the profitability was of certain firms. It caught lawyers' eyes, and many thought, well, maybe I should practice there or go there. Firms became multi-city firms. To do that, and they felt many had to serve clients who were becoming international clients with cross-border transactions and wanted one-stop shopping from their lawyers. So the firms felt they had to expand. But when you do that, you can't do it the same way you grew your firm when you were in one city. You had to grow by aggregation, which means you would look to other lawyers from other firms or groups of lawyers, and you would evaluate them through a very narrow set of criteria, like what's their profitability, how much money are they making, how many hours are their lawyers billing, and if you could attract them, they would come to your firm, having left a firm where they had no loyalty often, and if their expectations were not met in your firm when they came, they'd move on to another firm, and there wasn't necessarily cohesion. Uh, Actually, the geographic separation with firms operating in many cities played a role because you didn't go out to lunch with your partner. I remember when I started a major firm in Manhattan, in New York City, the partners had a table at a nearby restaurant. They would just go down there for lunch and talk about things. There was this degree of cohesion. We don't have that cohesion for the reasons that I've just mentioned. And then we've also had, I think, other factors that when I was when I got out of law school, I didn't know what an investment banker was. I'm still not sure
Right.
what an investment banker is.
Me either.
Although I would get involved in litigation with investment banks, I had never heard of it. If I had gotten out of college or law school, college, and said, "You want to go into investment banking?" I wouldn't have had a clue. And many of them make outsized earnings, and lawyers, I think, felt in many quarters a certain degree of envy. So I think that motivated people. And finally, I remember back in 1987 when this was emerging, the Finley Cumble firm was the first major firm to collapse, and I represented a particular partner in that. Excuse me. And what that firm was doing, and later copied by other firms, uh, it was hiring high-profile partners and basically borrowing, which many lawyers did not know that the management was doing, to attract these people. There was remember that firm, former Senator Lexalt, the former mayor of New York, Wagner, former governor, Hugh Carey, people like that. And they were borrowing. Actually, the firm later went into bankruptcy. And then I thought we had learned in the profession lessons from that, only to find in 2012 I got a call when Dewey LaBeouf went into bankruptcy.
They were borrowing money
They were borrowing money.
to bring these people on. Yep.
Yeah,
Okay.
exactly. You thought that people would have, or the firm leadership would have learned a lesson from what happened decades before, but apparently not. So I've described, I think, a number of changes, all of which contribute to the moniker business of law. And it's not just law. Think about medicine.
Hmm.
Think about the quality of how we regarded the profession of medicine. You
Yep.
know, I think the coin of the realm for professionals at one time, lawyers, doctors, accountants, and others, the coin of the realm was not money, but dignity, respect in the community. These
Yep.
were really important values.
And you had a mission. You felt not I don't have to say a calling, but you felt like this was a noble profession.
Right. And yes, and you enjoyed making a
Of course.
reservation at a restaurant and saying, "This is Dr. Jones," and everything. Oh,
Of
doctor,
course. Yeah, sure.
or judge. So that, I think, really gives, I think, for me, some understanding of these changes. I remember several years ago watching the Super Bowl, and there was a minute-long ad for major accounting firms, and of course, these companies pay a lot of money for these ads, so they give them a lot of thought. And the ad was very, very elaborate, all kinds of visuals, and it said boldly, "We are in the business of accounting." And I thought to myself, I thought you were in the profession of accounting. So, I mean, that's just one illustration of how this phenomenon has played out over the years.
Yeah, I think that that plays into a lot of professions. The profession I come from, old timey reporters and journalists would always just be adamant that you don't mix advertising and journalism. You don't let the advertising drive the journalism. And now it's not the only driver, but I'd say it's close to 80% of the driver, right?
Yeah, I see that.
It's about clicks and certainly profits. And now you're seeing the merge, and it is the business of journalism when, that was a profession as well. So it's not a great trend. I guess it's maybe one of the inevitable outcomes or a downside of capitalism, I suppose. I mean, I believe in capitalism, but, anything that goes too far, I think sometimes can ruin things. So you talked a bit about the centralization of in your chapter about the centralization of management decisions in law firms and how that's reduced the individual partner's influence. Has that change affected the dynamics of decision making within these firms?
Yeah, let me describe that perhaps for those who
Yeah,
don't really know the phenomenon that you're talking about. But first, thank you for mentioning my book. I'll mention it again if I may. It's
of course.
the name of it. It's Counsel, comma, the courtroom is open. It was released and it's being last week, and it's being widely distributed by Simon and Schuster. I'm going to be doing some book signings, Barnes and Noble in New York on Fifth Avenue, and others. If you put that title in Google or a search engine, Simon and Schuster publisher page will come up, and you'll see it's available in Walmart, Target, Hudson Booksellers. I think all the major retailers. But also, it's a little unique in that, as it says in the book, all of the author's profits are not going to me. I'm donating them to my son's not-for-profit organization that he founded called Grassroots Grocery. And with volunteers, they provide hundreds of families in the South Bronx and elsewhere in New York City food that would otherwise go to waste that comes into New York, and they distribute it in the community. I'm very, very proud of him. And
Should be.
yeah,
That's great.
to boost that, I'm delighted to do. But some of these things that we're talking about, I think all these things are in the book. It's got 40 plus chapters, but they're short chapters. It's quick reading. And I think there's a theme in many of these things, many of these cases. I mean, some of the cases are high profile cases. I try to take the reader behind the scenes into some things that I can reveal that were not in the public domain at the time of these cases. One of them I have a chapter called What Has Happened to Law Firms. And what I was talking about a few minutes ago is sort of described there. But to get to your point about management decisions, most of my 50 plus years of practice, other than when I was a young associate or a law clerk to a judge, I've been in boutiques. I started a boutique in 1981 with 4 partners. One of my partners now a senior federal judge here in New York. I've done a lot of public things that are discussed in the book. But there were 2 years, 25 years ago, where I decided to try something different when one of the boutiques that I had been a founding partner had disbanded. People wanted to do different things, retired. I became a senior partner. Well, it was the world's largest firm at the time. And I saw, and this was, I think, fairly typical, there was a tight management group that was essentially self-perpetuating, and the firm was growing, and they were acquiring groups, 5, 10, 20 or more lawyers at a time. And the executive committee would send out an email to, I think at the time was 1,500 lawyers. It became 3,000 lawyers. Firms have grown since then. The email would say, the following people or this group from another firm is proposed to be brought aboard as partners, and they'd have an attachment which would do a very complicated financial analysis of what that would bring to the firm. But the key part, when the memo would conclude, unless X% of the partners object, this will be effectuated in 48 hours, something like that. So the only people dealing with this would be the chairman, and tends to be a hand-picked executive committee, run, very much like a Fortune 500 corporation. Contrast that with, even then, 25 years ago, there were from old style firms where if there was a new partner or a group of partners to come in, the firm would insist that every and any partner in the firm, if it's a 2-city firm, it would be first, let's say in New York and Washington, It'd be a cocktail party or a lunch, and any partner who was interested would have a chance at least to say hello and chat with the incoming group, and would have a meaningful voice in the vote in whether or not the partner would, or group of prospective partners would, come to the firm. Contrast that with the other operation that I just described, which I think is becoming actually more common in the profession.
Yeah. Yeah. I gotcha. So what, from, I do like to look at kind of the next generation or the up and coming generation of lawyers. So one of the things you highlighted is, there's less time spent training and mentoring and lawyers because of, the cost that in itself doesn't pay right away. So what long-term effects do you think that's going to have on the quality of legal services and the development of the profession?
A very significant impact, coupled with one other thing that we should talk about, which is the increasing prevalence of remote, or almost always remote work. Okay. The mentoring we're talking about, uh, it takes place most effectively in in-person meetings. It could be going out for lunch, going out for a beer, chatting in the office, in the cafeteria, stopping in somebody's office and just chatting when, people have a break. This is something I'll just expand on a little because I'm sure it will resonate with your listeners. Remember, starting in 2001, when COVID hit, at a time when technology was adapted to this, we began going remote. Nobody could get together. Law firms tried to adapt, but that created a new plant growing. It created a new phenomenon. So when the COVID, or the worst of the COVID, ended a year and a half later, remote work, Zoom, all these services that provide a remote work, include courts began, who had operated during the COVID period remotely, began to operate with people remotely. Great efficiency, reduced cost, all great. But where is the mentoring? We have now, we're in 2026, 5 years after COVID. We have lawyers who are 5 years out of law school and know nothing but a two-dimensional screen, which they sit in front of in their pajamas. I mean, this has happened in a great part of the law profession. As the other phenomenon, I think, which you correctly mentioned, is clients who, to a certain extent, are less trustful of lawyers as law has become a business, and are much more at arm's length with their lawyers, than feeling they're joint in a common venture together to advance the client's interest. They don't want to pay for the training of the lawyers on their dime. That shouldn't be billed to them. And if they're not going to pay for it, frankly, many of the law firms aren't going to absorb the cost themselves. Uh, and you know, Another phenomenon we've seen, would be a whole other topic, is what's these incidents. And there was a major one with a major law firm today in New York. It's all over the papers. But what AI has done with people, putting citations in their briefs that are hallucinations, right? I don't think that's I think that's just peeling the skin on something else that's been going on as law has become a business, which is much less attention, time spent in preparing legal products like briefs, really reading the cases. I mentioned, and this is in line with your theme. When I started practicing over 50 years ago, if I would draft something as an associate, and there'd be a partner in charge, the partner would say, "Give me your draft brief, but give me the cases you're citing." And the partner would spend the time on not only reading the draft, perhaps editing it, making suggestions, but would read the cases himself or herself to satisfy them that the cases were being properly employed as authority in the work product. Again, as laws become a business, as clients don't want to absorb learning time, and they're more scrutinizing bills, a lot of that has fallen by the wayside. And I think what's happened with these instances of firms submitting things, with AI hallucinations, which reflect that people didn't read the cases, I don't think that's new. I think that's happening. It's just not uh, so uh, clearly come to the surface, which is probably made worse by these faults of using AI.
Yeah, I do think that both with remote learning and with AI, or not remote learning, but remote work and
Yeah.
AI, I think I think those things are here to stay. And I think now it's a matter of let's make them work properly. Like my experience with AI is you would never, I do a lot of writing and I use AI for drafting. You would never turn in the first draft of anything from AI without going over it yourself, almost like a very junior person. And there just have to be rules like that. But it does speed some things up tremendously. Um, but you've got to have the checking and the oversight and the very critical eye if you look at something. Also, too, you've practiced for quite a long time, and I've done what I do for quite a long time. I think we're in a position too. If we use it, I don't know. I've been an editor for 40 years. I look at something with an extremely skeptical eye, critical eye. I'm like, is that right? And so I don't know. I find it expedites some things, but you cannot let it be your final editor, I don't think. And in terms of, and some hallucinations are just crazy. If you haven't checked your cases, yeah, that's just wrong. Now, I've started recently using LexisNexis. They've got a service protege, and what I early on learned about using AI is that it has to point at things that are authoritative, and Lexis does that. And my gosh, I ran a search on that and compared it to a search I did on something else. This isn't a plug for Lexus, but I mean, the details were amazing. It showed every case and it showed the, what's that called? The shepherd signals. And, so it gave you the roadmap for checking everything. But I do think that people who use it irresponsibly, yeah, that's just not
I
good.
think there's a deeper problem that I've not heard talked about with AI. And let me give you my thought as to where this will happen. And again, this is much deeper than hallucinations, which we're all familiar with this. It's one thing to use it for fact checking, point you to things. Say you're a judge and you've heard testimony, you have a case, complicated facts, and the judge says, with all this, what does AI think about the result and explain it? Now,
Mhm.
AI will lay out a draft opinion, taking however it does it with all this stuff. And now it's happening. It's not a question of fact checking. It may be thinking as a substitute for the judge thinking. And what we expect is the judge to be doing the thinking, not an algorithm, not an
Right,
AI. And I've not
right.
seen that talked about, but I'm concerned about that. Uh, and same thing if the judge's law clerk, let's say the law clerk sits with the judge, either reads the briefs, it's a summary judgment motion, or there's been a trial. A law clerk has always provided, their analysis, subject to what the judge is saying. But now the law clerk's analysis, like the judge, is not the law clerk who's gone to great law school, was a great student. It's somebody else unknown to the judge. Somebody else is writing, is deciding what goes in that opinion, which is not simply AI responding to, well, who was elected president in 1836? Fine, you want
Right.
Martin Van Buren. Okay, that comes to mind. But I might want to confirm that. So that's really a danger that I don't think has been really talked about yet.
Yeah. Yeah. Well, yeah, I think you don't want it to do the thinking for you. I think just to briefly add on to that, and we can move on. But um, what my experience with the AI just over a few months is, um, if I'm writing a piece, I do give it my take. I think first. I load that in. This is what I think. Help me expand on it and see what it comes up with. But I get your point. I mean, it comes down to using it responsibly or not. And if someone just says who should win this case,
Right.
okay, that's irresponsible. I mean, it can be an amusing game, but and like with remote work, I mean, they're just I just interviewed an attorney. He came from big law also, and he said COVID it just drove him out of the law profession because he didn't like practicing by Zoom. As you said, he got a lot out of the personal interaction and body language and everything else, and side conversations, the things you can't have just looking into a camera. Um, and as somebody who does now work remotely, I miss the interaction. So for some things, I think, gosh, it's got to be about balance, because there are some days when I'm doing nothing but heads down, writing, and researching, writing. I don't need to be around anybody, but there are other times when I need to poke my head up and see what other people are doing, what else is going on. I do miss that interaction. So
Hey,
I don't
it's
know.
a little vignette, something that occurred to me. It's consistent with what we're talking about. I'm seeing in this day of, I'm in many cases where we have either a number of clients on our side, all have lawyers, or have a client's got 3 sets of attorneys. It's a major litigation, which is very common, and you have
Right.
a whole group of people. And somebody says, "Can we have a conference at 1 o'clock?" And I frequently get that. And I actually responded lately, "No," I said, I go out for lunch. Why? So it's another thing. I'm not, being facetious a little, which is the work style of lawyers, particularly with remote work, and something else I want to point to. When I started practice, I'll tie this all together in 30 seconds for you. When I started practice, I think the profession was largely male dominated. In New York City,
Sure.
one wager often, the female spouse would be focused, at home. And there was actually, the law firms were open on Saturday half a day, even required work. And even on Saturday, the lawyers would go out with the senior partner Saturday afternoon, for lunch, and then not
Mm,
home till dinner, close to dinner time. And much more is the case now, where there are two workers, two professionals, two people sharing children, child responsibility. And so how has that changed practice? Lawyers, if they're in the office or on Zoom, they don't take a lunch, but they don't go out for lunch with their colleagues. If they're in the office, they want to get through, finished for the day, and get out. Now, okay, that is efficient. It is a change, though. So when I started practice, pretty much every day, an associate would be invited out to lunch by the partner for whom the associate was working, or a group of 3, 4, 5, 6 associates, would go out together pretty much every day. They may not go to the fancy restaurants, but they would get together and just, I remember the conversations. Who's up for partnership? What's happening? How's he doing? Oh,
hmm
how is it working for partner X? But these people were sharing information, bonding, and when you go out with your colleagues, maybe somewhere a year or two ahead of you, you learn from them. It's like in college. You're a freshman. If you go out, have a beer with some seniors, you'll learn about what to expect, what
Right.
fraternities to go to, right?
Yeah.
Which partners to avoid, all of that stuff. So a lot of that's gone. So I say,
Yeah.
no, I don't talk at 1 o'clock. I wouldn't.
No, it's
I'm saying I want to be with somebody. A
right.
client, a colleague, a judge, get known in a bar association meeting.
Yeah.
That's another thing. What is really, I think, one institution that suffered is the bar association. I use that collectively for all the bar associations. Their membership's down. The ABA is way down. I think the New York State Bar Association, where I am, it's an excellent organization. It's had a lot of challenges. Had to, rethink what it's doing. Some bar
Mhm.
associations, there was one in New York, the New York County Lawyer says, had to sell its landmark building to stay in business, I think, to help it stay in business. Um, and why are bar associations on? Because as the profession or the concept of a profession suffers diminution, people less and less see the value in bar associations, right? And where I think we see the same phenomenon in the community at large when we think about colleges. People are saying, one point when I got out of college in the 1800s, people would say, actually it was the 1900s, but in actually, people would say
I was going to let it go.
it's all right. People would say, get a liberal arts education. Now, it is true that there are many people that would benefit from a specialty education because they're good at it,
Absolutely.
will make a good living. But college was not thought only to be about what you're going to do for a job,
That's right.
right? Okay. It's changed a lot. People, and of course, as tuition has skyrocketed, way ahead of inflation, I can understand that. People say it. But so if you have people, colleges have kind of become expanded high schools in many ways, and their curriculum is a little more, shall I say, flexible for everybody. But it's all sort of part of the same common phenomenon, I think, which is the value of becoming a professional, academic knowledge, Not every bit of which you're going to use in your job has value. And coming back to the lawyer, the profession of law, look, it's even affected law school curriculum. We, all of us who went to law school some years ago, particularly the better law schools, were exposed to history of, the common law, how we got here. You have lawyers here. They might be. I was doing a CLE, running a panel for a group of lawyers for commercial litigation. These were people attending, had several years experience, some much more experience. And the topic I was talking on was preliminary injunctions. And if you have litigators in your audience, some of the recitations that are in the pleadings when you ask for preliminary injunction. So I asked the group, I said, how many of you have been involved in preliminary injunction litigation in federal or state court? Almost all the hands in the audience went up. I said, how many of you have seen in that, in a request for preliminary injunction, plaintiff has no adequate remedy at law? That's very common. And hands go up. They've seen who can tell me why it's in there? No hands went up. No hands went up. So then I had to talk about, the evolution of law and equity being separate courts in England. And you go to the law courts, which had very rigid pleading requirements, and they say, I can't give you relief. Go down get on your horse and buggy and go down to the different court system, the equity courts, which were filling in the interstices. So if you wanted to get into that court, they'd ask you, don't you have an adequate remedy in the law courts? And then another thing we see, clean hands, right? You see that it's not just about people going to the washroom and washing their hands. You have to, be morally upright in the cause, right? To get it relief in equity. So that would be another requirement in equity. But what's this all about? It shows that the focus in what was a profession for important education, its value has been somewhat downgraded.
Yeah. You mentioned in the context of both the remote learning and the associations and protecting your lunchtime, all of that, those things, it seems like there is less opportunity for, I don't know what you call it. It's not hard work, but it's soft work of getting to know somebody else, getting to know random information that you might want to learn. And that's where you pick that up. That's at those lunches. It's association meetings when you get together with colleagues you haven't seen in a while. So I think that's a key point you're hitting on there, that maybe we're getting too isolated.
We've talked about lunches, but sometimes I go out not only with lawyers, but with staff. I want to see what they're seeing. What are they seeing
Of
in the law
course.
firm? What are they perceiving? It's useful to know apart from knowing them personally.
Yeah.
Someone
Yeah.
tell me about a problem I didn't know about in the firm,
Right.
or any number of things.
That takes a lot of trust, doesn't it, though?
It does. Yeah. Well, you develop that. And somebody has
Yeah.
to trust you if they're gonna. But you're not going to get that talking on Zoom.
No, you will not, especially if it's recorded.
Yeah. Right.
So that's good. Okay, well, we talked about the professional law, so we can skip that. But you touched on the impact of recent political events, presidential executive orders on law firms, and that's just such a huge story, and I'm just riveted by it to see how it comes out. But it was particularly regarding the DEI policies and pro bono work. So how do you think these are going to shape future priorities and values of major law firms, and how do you think this is going to play out?
Well, let's start with what we saw. We saw somewhat of a divide in the community between those that hustled to really comply with what the administration was asking and others who fought back. I guess nobody would know on day one, whether the courts would protect what law firms wanted to do and not comply or be told by the government what to do in their policies. So that's still playing out to an extent. I do think there was a certain irony in that certain firms that comply readily, again, for acknowledged, quote, business reasons, right? Unquote.
Yep.
Talk about the business of law. Where so leadership was put in a difficult position um, because many of these firms grew and achieved great financial success, particularly litigation firms, by taking on business lawyers. I think I think some of your audience, your legal audience, will appreciate it. Firms that just did litigation, I think made a calculus that we can't be stopped from going to the courts. The judges won't permit. But if you were a lawyer serving businesses in deals, mergers, acquisitions, we know those firms have to get the good graces of government. They're dealing often with government agencies that they have to meet with, and now they're being banned from the buildings if they don't comply. They can't advocate for their clients or get their mergers approved or their all of that. So I think that the increased dominance of that aspect of the firm of business lawyers had a role, I think, in many cases in determining, how a law firm would respond to the demands.
Right.
But I don't want to get into the politics of it. I'm
No, of
an
course not.
observer, so to speak. I do think it's ironic that some of the firms boosted their PR, handled their PR by advertising their DEI very proudly, and then overnight it disappeared. Or in some cases, there were actual resumes of their lawyers, on their websites, and sometimes people want to, of course, put their achievements in their bio. Some of them would say, "I worked on the Mueller investigation," or something else.
Yeah, right.
That's gone. I mean, it's like
Yeah.
stripped from the resume in some firms. But I
Yeah.
understand firm leadership was in a. I do. In fairness, we're put in a very uh,
Oh, yeah. No
difficult
question.
moment. They had legitimate concerns for their firm and the people whose lives depended on the firm income and all of that. No question.
Yeah. It was a gamble. It could certainly put a firm under. And I think, in a couple of years, it'll be interesting to see how it played out for each of these firms. You mentioned some things that are happening, where people adjust their websites and their bios and things like that. And I know that I need to confirm this. I'm fairly sure there is one major client that left one of the capitulating firms and went to a firm that stood up. I've got to confirm that, but I'm pretty sure that's the case. But that's one case. Who knows?
Yeah.
But yeah, I don't know. To me, in my mind, I was thinking, because I dream like, what would be the perfect response that would have been if all firms in the country said no? Then what do you do? But that's I'm being a dreamer. So, do you see anything positive about the way things are going today, or do you think it's all kind of like just not great the way things are changing with law firms?
There's a saying, two things or more can be true at the same time.
Yes, I
So
can.
yeah, um, I think the profession itself has tried, sometimes successfully, to address some of the things that were affecting us beginning of the 90s. Talk about civility, right? That, it was observed, that beginning in the 80s, that the morals or the norms of conduct had changed. People, the way lawyers in a litigation would act to each other, it sometimes get very crude. And there have been examples in the case law that have made this very stark. But perhaps not wanting regulation from outside, many of the bar associations and related entities like the courts have taken steps to educate the profession about proper conduct and the fact that we are a learned profession, so to speak, and the best of that. Give example, I know California, I think some other states now, when lawyers come into the bar, they have to take a civility pledge.
Really?
That's a requirement, and we have in New York, and the bar association that I was a leader of years ago developed a code of civility, which the state authorities then adopted, which is kind of precatory to educate lawyers as to how they should conduct themselves in court litigations, not as a basis of sanctions, but as guidance. And increasingly in our literature, our judicial literature, these guidelines are being cited as models, when there are problems with lawyer conduct. So I think they've had a salutary effect. You ask what's positive. I think that's positive in the profession. Um, what I don't think is positive is the unfortunate Supreme Court decision some years ago that allowed virtually unfettered lawyer advertising. So any of us who have ridden on a New York subway or bus looks up and sees an advertisement for a law firm. We see them on billboards on America's highways, and they say, the biggest thing you see is the number $100 million or $1 billion in verdicts,
Right.
with a little somewhere on the bottom, which is past performance is not a guarantee of future results. But,
Right.
I think that has diminished the profession. The thinking of that was I think very good at one point, and I understand
Yeah.
in the Supreme Court decision because what they were trying to achieve was to create competition and ultimately lower prices for consumers, which is always
Mm.
a good thing. Bar associations or had suggested or required prices that the members would charge their member lawyers for particular services, doing a will, a real estate transaction. So when lawyers get advertised, they would, and it would perhaps lower the prices. What it reminds me of? In 1978, the airline industry went off regulation on pricing. You used to buy an airplane, the prices were high. It created competition. Some of these airlines, I remember Freddie Laker's Airway, it was cheap. That belonged
Yep.
out of business. We have
There were a
budget.
couple thousand airlines in the
Yeah,
80s.
I saw one today seeking a rescue from the government, or they're going to go bankrupt. So,
Spirit. Yep.
you want to, is it good? Is it bad? One time, anybody who had a ticket on an airline, if you look at the pictures from the 1950s, if they're a man, they're wearing a suit and tie and a hat.
They look like you.
Now they're dealing with, yeah, right. I've had this on for many years. So right
No,
now,
I know.
they're debating whether they should allow passengers on in pajamas.
I don't know why I find it so funny, but I think people are funny that they think that that's, I
Yeah.
don't know, they're comfortable. And when I would take my girls on vacations and things when they were teenagers, and yep, pajamas and a pillow for long flights. But but no, I know what you're saying. I know what you're saying. But yeah, no, with airlines, that's another issue where they've merged so much. I just looked this up the other day, and I don't have the right numbers. In the 80s, there were several thousand law firms. I mean, not law firms, airlines, and now there's like four big ones and then a few dozen smaller ones. But
Well, before deregulation in 78, you pay a high price for a ticket. If you went to the counter and you had a ticket on American Airlines and you looked around, it was delayed or it wasn't for a while, another airline, Delta, was going to the same place. You'd walk to the Delta counter and they'd take the American Airlines ticket,
oh, really?
all the same high price.
Huh. Okay, I gotcha.
Remember that? I do.
Yeah, that's well, no, I wasn't traveling much then, but no, that's wild to see how that has transformed. But you're right. You look at old movies of the flight attendants, formerly known as stewardesses, and then the way people dressed. You're right, but you could just walk up to an airport and get a ticket and go somewhere.
Yeah.
And nobody's checking. I don't think there was. When was security? I don't know when security started to
It
happen,
was
but
no. And you didn't have to show 9 forms of identification.
no, no, no. And I've gotten caught up in that because my full name is William Thomas Hagy, and I am William T on many documents.
Yeah.
And I have been stopped and have to explain, I'm Tom, but, my dad wanted me, it's just, and they said, well, next time we're turning you away if you don't have the right. I'm like, okay.
Well,
I travel with my birth certificate now,
next time I buy a ticket, I'm going to take your name. It's a lot easier than mine. And, I have to repeat it several times.
you, okay. So one last thing, what about, so we're talking about the future a little bit. You've got people looking at, should I go to law school? I want to go to law school. What would you say to either people entertaining the idea of getting into the profession that's now a business, or, newer associates? What advice would you give them?
I'm high on the law profession for some of the reasons that I've expressed. In my view, it's a profession. It's intellectually interesting. There's variety in it. You deal with people. You get the satisfaction of helping people in difficult situations because of your knowledge of substantive law and over time the procedures. You tend to get better at it, which is very satisfying. From experience. When you come out of law school, even though you have substantive knowledge, you don't know how to handle a litigation. Even if you took a course, you don't have the judgment, you don't have the experience. You learn that, and that's very satisfying. I think if you like what you do and you work in an area, you do it well, the compensation will follow. I never
Yeah,
thought about money when I started. My job as a law clerk, it was the greatest thing. I was thrilled to get it.
sure.
$9,500 a year. Senior law clerk made 11,000, so I was a little envious.
Yeah.
Yeah. So the money will follow. the satisfaction is what's critical to me, and feeling also you're doing something useful. You're helping people or helping a cause. That's an added benefit, and it gives you the opportunity, which I spent a lot of time and a lot of things that are totally uncompensated. Whether Bar Association work, I have been privileged to head various commissions in New York. One that examined New York's jury system, the commission on the jury. It was a Blue Ribbon panel. We had hearings at 140 witnesses to think what's going right or not right in the jury system in New York, where 60,000 people are called every year to jury service. So as a lawyer, you have the opportunity to do it. And I like private practice. In my case, I like small firm or boutique practice, but there are many, or you can enjoy being in-house and working in a corporation or doing legal aid work or doing criminal law. There's so many opportunities, which I think only really come to you only have the ability to make those choices after you're in law school and you've had some experience, or even out of law school, you try a particular job, but you don't like it, you move in a different direction. All of that is available to somebody who takes a chance and spends the money. I recognize it's expensive, but if you work at it and do decently academically, there are very large academic scholarships, very significant ones available. I know I've created 2 scholarships at a law school that's not a first-year law school because I think they needed it. They're helping people in the community become lawyers who have worked at jobs, and want to advance themselves. So I'm all for advising people to enter the profession.
Okay. I'll just piggyback slightly on that. Some people that are started off in law and they ended up with fascinating careers where the law was applied, but they became a CEO. They became a journalist, all kinds of fascinating things. So, I'm still a big fan. And even though I didn't go to law school, I was a horrible student. I think by the time I was 30, I could have gone, but I spent my whole life studying it. And to your point about it being intellectually interesting, that's what's kept me doing it for 40 years. I think it's like philosophy, except at the end, there's a real impact on somebody's life.
Of course.
It's very cool. Well, Mark Zauderer, thank you very much for talking with me about this. And I'll make sure everybody knows about the book and where the proceeds will go. That's all good work. So thank you very much.
Thank you. My pleasure. Good to be with you.
That concludes this episode of the Emerging Litigation Podcast with Tom Hagy. The program is produced by HB Litigation News, a brand of critical legal content, provider of writing and multimedia services for boutique law firms and specialized legal service providers. If you would like to reach us, send an email to editor@litigationconferences.com. And if you like what you hear, please share this episode with colleagues and give us a rating. Tom operates under the assumption that helps, and let's face it, he's always looking for validation. I don't know why he needs it. I think you will agree that he is an amazing professional. Yes, he told me to say that. Anyway, thanks for listening. It warms our cockles and gives Tom a reason to get out of bed in the morning. Oh wait, hold on. What's that? Sure, but we already ended the episode. Fine. Okay. I said okay. Sorry. Me again. Tom wanted you to know that he's playing bongos on the theme music. Are you happy now? Like I said, validation, constant validation. Now we really are at the end of the episode, and I am about at the end of my rope with this guy. Goodbye for now.